versus Bangladesh, reported in 20 BLG AD 104, provided that a 12-point directive to materialize the separation of judiciary. I believe it would not be wrong on my part to say that due to the concerted effort on the part of both the bench and the bar, Bangladesh has come a long way in implementing an independent and separate judicial system. Suffice it to say, independence of the judiciary is the cornerstone of an ideal legal system, and Bangladesh as well as United Kingdom are not different. We have also recently observed a major constitutional reform in the United Kingdom, whereby the Supreme Court of the United Kingdom has been established to achieve a complete separation, as I believe, between the United Kingdom's senior judges and the upper house of Parliament, thus emphasizing the separation of power and increasing the transparency between Parliament and the courts of law. The independence of the judiciary enables the judges to apply the law rationally and evenly. In the words of John Law, the purpose of judicial independence was to ensure that the law would not be varied in particular cases, but be the same for rich and poor, for the fair play court and the continuing law. An independent judiciary has long been recognized as the foundation upon which true democracy rests. It ensures the establishment of and adherence to the rule of law, which decrees that the law must stand supreme and to be evenly and fairly applied to every member of our society, including public officials who must carry out their duties in accordance with law. The rule of law allows us to live together in freedom and harmony and provide the common ground of social progress and prosperity. Recently, the verdict in the case popularly known as the Fifth Amendment case in our jurisdiction has come as a clear denunciation of military takeovers of state power and a message against extra-constitutionalism. The judiciary has, in unmistakable terms, upheld the core values of the original constitution and thereby restored its own image as well. It is my privilege I have been a member of the same bench and one of the author judges. The verdict is a severe indictment of military takeovers and the usurpation of power by extra-constitutional means. It has demonstrated in unmistakable terms the truth that the judiciary is often called upon to uphold the law and the ethics through raising and placing on the highest the principles and core values a nation must live by. Mr. President, this award will inspire and encourage me and our judicial system to work with greater vigor to promote the administration of justice in Bangladesh. Reforms in our judicial system is an ongoing process, and this honor will act as a renewed impetus for making our judicial system more suitable for the social, economic, and other needs of the people. Bangladesh, like any other developing nation, has to deal with the immense gap between the haves and the have-nots. In our endeavor to attain an efficient and fair judicial system, we have always paid special attention to the needs of the part of the society who are unable to afford high cost of litigation. Besides the problem of financial constraint, a significant part of our population also suffers from lack of proper education and access to information. In order to achieve an efficient and fair judicial system, we will provide utmost priority to access to justice. As a result, our judicial system is being restructured in a way so that each and every citizen of the country has proper access to justice. Steps have been taken to promote quick disposal of cases and to reduce backlog of cases. Moreover, our laws have been amended and the judiciary on its own have also been promoting and integrating the alternative dispute resolution ADR system so that the citizens of our country can afford the hardness of litigation. ADR is being particularly encouraged in family cases as well as in bankruptcy and default of loan cases. And we are also trying to extend the same. We have also, in recent past, some amendments in our civil procedure code. Furthermore, we are also taking advantage of information technology in modernizing our case management system, which has been benefiting the judges, lawyers, and the litigants. Ladies and gentlemen, it is very important for us, the judges, to ensure that public confidence remains in the ability of the courts to dispense justice. Public confidence in the courts is based on perception of the justness of judicial decisions. The efficiency, the efficacy of the judicial system, the integrity of judges. In order to have an effective judicial system, the judiciary must play a proactive role in facing the new challenges and developments in the society to ensure that the disadvantaged and vulnerable section of the society, especially the poor, women, marginalized, are provided with full protection and equal treatment in accordance with the fundamental rights as enshrined in our Constitution. In our Constitution, there are special provisions to make even some discriminatory treatment to give some relief to the disadvantaged and marginalized sections of the society. Before I conclude, I thank for his gracious presence here this evening and recognizing the Judiciary of Bangladesh and also honoring me in this occasion, which I believe will always guard and uphold the fundamental rights and rule of law for the people of Bangladesh. Thank you very much.
I would now like to introduce Lord Phillips, President of the Supreme Court of the United Kingdom, and invite him to say a few words.
Thank you. Chief Justice of Bangladesh, Your Excellencies, distinguished colleagues, ladies and gentlemen. I am delighted to be here with you for this final session and to have had the honour of presenting this year's awards. What I wasn't expecting was to find myself receiving one of these awards myself. And I am very grateful indeed to the International Conference for conferring that honour upon me. A number of the topics that you've been discussing at this conference have a particular resonance for me as President of our new Supreme Court. You started with accountability and judicial reforms. The Constitutional Reform Act of 2005, which created our Supreme Court, has stimulated, among some at least, a demand that those who are appointed justices of the court should be made more accountable by some form of confirmation hearing. It may not surprise you that this is not a reform that I would view with any enthusiasm. Human rights and terrorism. The tension between protecting human rights and protecting society against acts of terrorism is one that has proved a particular challenge for the Supreme Court. Not all have expressed satisfaction at the manner in which we have struck the balance. Indeed, some government ministers have not hesitated to express dissatisfaction with some of our judgments in terms that might almost be described as immoderate. Which leads me to the next topic, relations between the judiciary, the legislature and the executive. The principal object of of the creation of a Supreme Court in this country was to make transparent the separation of powers. It has, however, exposed us in a way that we were not exposed when we were law lords to the accusation that we have been usurping the role of the legislature. Rather than expand on these topics at this point, which is what I was invited to do, I propose to explain how it is that we have come so late in the day to have a Supreme Court. For 400 years, the power of Parliament went much further than merely making laws. Individual citizens could appeal to the House of Lords against judgments given against them by the judges. The House of Lords then debated the merits of the appeal and voted on whether it should be allowed or dismissed. Some members of the House of Lords had legal experience, but most did not. And so the decisions of the judges could be overturned by members of Parliament who were not lawyers. This was not a satisfactory state of affairs, and as time went by, a convention developed under which only those members of the House of Lords with judicial experience took part in the judicial business of the House. The next step, and we have now advanced to the year 1876, was the creation of a new kind of lord. These were senior judges who were made members of the House of Lords for life and whose job it was to perform the judicial duties of the House. They were known as the law lords. Any appeal from a court to the House of Lords was heard by the law lords sitting as a committee of the House, and only the law lords who heard the appeal could vote on whether it should be allowed or dismissed. In recent times there have been 12 law lords. They were in effect the final court of appeal of the United Kingdom, but they were nonetheless full members of Parliament. I was made a law lord about 12 years ago, and I found myself in a very strange world. We were accommodated in little attic rooms in the Palace of Westminster. Our judicial assistants were lodged in a garret in the roof space, and there was only room for 4 of these, whom we had to share between us. We sat to hear appeals, usually in panels of 5, in committee rooms of the House of Lords, just like any other parliamentary committee. Technically, we were not judges, so we wore no judicial robes. So far as delivering judgments was concerned, the old formalities were observed. We moved to the floor of the House at 9:45 in the morning, before the hour at which its normal business began. Proceedings had to be commenced in the normal way, the business of the House, with a huge mace being carried in and put in place, to which we bowed. Then the duty bishop would read prayers. The senior law lord would then sit on the woolsack to preside, and the rest of the law lords who had heard the appeal would sit on the parliamentary benches. The senior law lord would propose the motion that the appeal be allowed. Each law lord would then, in order of seniority, get to his feet to deliver his speech or opinion in relation to this motion. This was in reality his judgment. The senior law lord would then put the matter to the vote and announce whether the appeal had been allowed or dismissed. Although our function as law lords was to transact the judicial business of the House, we were full members of Parliament. We could take part in the legislative business, speaking in debates and voting on bills, although by convention we tended not to do so. But I only had the briefest of spells in this fascinating world before returning to the Court of Appeal to preside over its civil business as Master of the Rolls. It was in that capacity, on the 12th of June 2003, that I found myself at a delightful inn called the Swan, in the depths of the country outside London. The Swan had been converted into a conference centre, and I was one of a number of England's top judges, including Lord Wolfe, the Lord Chief Justice, who were taking part in a 2-day meeting with the most senior officials in the Lord Chancellor's department to discuss the future of our justice system. When we came down to breakfast, it was to learn that Tony Blair, the Prime Minister, had just announced some sweeping constitutional changes. The Lord Chancellor was to be abolished, to be replaced with a Secretary of State for Constitutional Affairs, who would have